Hello everyone, and welcome to our fall virtual seminar series. I am AJ Weisler, a partner in Husch Blackwell's Labor and Employment Group, and I am honored to get to serve as your host today. This is our national seminar, and we have people joining us from all over the country. And we also are going to be joined by an extremely talented lineup of Husch Blackwell attorneys who will be presenting to you today. And we have an extraordinary team of people who are working behind the scenes to allow us to meet you wherever you are today and present on a number of very interesting labor and employment topics. Before we begin our presentations, we do have to address a handful of housekeeping items. Hopefully on your screen you'll see at the bottom a number of icons for apps that are available to you today, and some of them will be relevant throughout and others for specific purposes. So you might have a question at some point today about one of the presentations, and if so, please do send it to us through the question icon below. If you submit it during the presentation, we will try as best we can to respond to it today, or we may follow up after the presentation is finished. You'll also notice there is a resource folder, and you'll find a copy of the presentation, and you'll also see other resources available to you there. For those of you who need it, this program has been approved for HR and legal education hours. And there is an icon that allows you to report those hours called the CEU icon at the bottom of the screen. You will receive a certificate of attendance, including the course numbers, that'll be emailed to you tomorrow, along with a link to the recording of the broadcast so that you can relive and re-enjoy the experience we're about to have together, or share it with others. Toward the end of the program, please do take some time to complete our short survey and give us feedback on the information that you received and what topics you'd like to see us provide in the future. You know, we rely very heavily on our audience and our friends, colleagues, and clients who are out there listening to give us ideas on what it is that will help you best in the future. Excuse me. And that is all for the housekeeping items. So we're going to move on now to our substance. So there are going to be 5 sections of content for you today. In between each of them, there will be a short break, sometimes with the poll question, sometimes without. We'll have a longer break of about 10 minutes during one of those sessions, and that's when I get a chance to talk a little bit longer with you all about a topic that's very important to me. Won't give too much away at this point. And our first topic today is going to be presented by Tricia Moore. She's going to be presenting a discussion of recent National Labor Relations Board decisions, actions by the General Counsel that will impact union employers and non-union employers alike. So Tricia, take it away.
All right, good morning, everyone. Thank you, AJ. Excited to have you guys with us today. If you are joining from home, if it's your morning, your afternoon, good morning, good afternoon to everyone. What are we going to talk about today? Things are pretty crazy at the Labor Board if you have not heard. So we're just going to dive right in. Buckle up your seatbelt because you are in for a roller coaster ride. We're going to talk about a couple things today. First, we're going to talk about changes to NLRB elections. A big case came out last week, and we'll dive into that. We'll talk about union activity. We'll talk about voluntary recognition. Now, I know some of you might be thinking, oh gosh, we're never going to get organized at my facility. My employees would never be interested in a union. Unions would never be interested in us. Sit tight. Sit tight before you make that final decision. We're also going to talk about workplace rules and handbooks. Everyone has one. And then at the end, we're going to talk about concerted activity when we wrap up. All right, so first off, union activity, elections, and voluntary recognition. I want to talk about a couple numbers before we dive into some of these cases. So if you go to the NLRB's website, they have a lot of data about cases, intake. So between January of this year and June of this year, the board held 827 elections. Now, that's not how many petitions were filed for elections. That's actually how many elections were held. Now, that number isn't necessarily substantial when we compare that number to past years. It's actually pretty average, maybe higher than some years, lower than some years, but pretty average. Unions have prevailed in 80% of those elections. Let that sink in for a minute. Out of those elections, almost 60,000 employees have joined unions. 60,000 in the past 6 months. About 14,000, a little bit over 14, almost 15, have joined SEIU. And you might be asking, well, why is it that SEIU had 14,000 employees, almost 15? That's pretty crazy. Well, there were a couple large-scale elections with a few thousand employees, mainly residents. And when I say residents, I mean medical residents who are employees at universities, working on their residency. So resident organizing is hot and heavy right now. Have you heard about what's going on at Amazon, at Starbucks, at Apple, at Trader Joe's? You know, it isn't just at the, facility where they have drivers anymore. I mean, it's people that we are interacting with every single day. Union approval rating is hovering between 68, 69, 72%, somewhere around there. Hasn't changed much over the past couple years. That's pretty steady. But union membership is up by about 26%. So you might be saying to yourself, well, why is this so important, Tricia? Why do I care about that? I don't think my employees would ever be interested in a union. We don't have a union here. Never going to happen. Well, let me tell you what just happened. August 25th, the board issued a decision in CEMEX Construction Materials Pacific. This case was actually out of Region 28 of the National Labor Relations Board. If you are an NLRB nerd like I am, you know that Region 28 is hot and heavy. With cases, they're very busy, and their regional director loves to go to trial, and this is a huge case. So what did CEMEX tell us? I'm not going to dive into every detail of the 121-page decision, but Cliff Notes version, here's what happened. Had a big organizing campaign at a CEMEX company, CEMEX, and the company allegedly committed a number of unfair labor practice charges during the campaign. So the board issued this decision saying, okay, union, here's what we're going to allow you to do now. Instead of you having to go to the board and file a petition for an election, what we will allow you to do is to get 50% plus one of the authorization card signed from the group of employees that you want to represent, let's say the warehouse employees. Take that 50% plus one to the company and tell the company, hey, guess what? A majority of your employees want to be represented. And so you need to voluntarily recognize me. Well, as a company under CEMEX, you have a couple decisions. And you had this option before. You could say, okay, great, we'll recognize you. Well, we would always counsel employers, no, don't recognize, have the union go and file a petition. Well, now, under CEMEX, the union does not have to file a petition. All they have to do is ask for voluntary recognition, and now the requirement is on you, the company, to go file a petition. You have 2 weeks to do that. Let's say you forget and you don't do anything, or you don't want to deal with it, or you forget to pick up the phone and call us and ask us what to do. The board will issue a bargaining order. What does that mean? That means without an election, the union automatically becomes the representative of the employees that it petitioned for. Let's say you do file that RM petition timely and you're going to go to an election. But during that time, you commit some unfair labor practices. You maybe make some inadvertent threats to employees. Well, what the board says is during that time that the union asks for voluntary recognition between the time of the election, if a company commits a ULP, the board will issue a bargaining order. And there are some specifics behind whether they will or whether they won't, depending on the kind of ULP. But generally speaking, the board will issue a bargaining order. So potentially you could have a policy. You could issue a legitimate discipline to an employee. And from that, you could get a bargaining order, even if the employees elected to not have a union represent them. So that's how crazy things are at the board right now. So what can you do? Again, so many people think we're never going to have a union organize us. But what I want you to think about is training your leaders, training your managers and supervisors to really understand what are the early warning signs of unionization. Many times we just don't know. Are our managers and supervisors aware if they hear employees talking about engaging in union activity, that that's to be reported to us? And are the frontline leaders aware of what that reporting trajectory is? They may not know. And then ask yourself, when it comes to employees, what are we doing to ensure that our employees are not interested in joining a union? Are we giving our employees a voice? Ask yourself, how are we doing that? Are we showing employees that we care about them? Are we rewarding them? Are we showing them appreciation? And if so, how are we doing that? And is that sufficient? Do our employees feel safe coming to work? Have our employees made complaints? And when they do we listen and do we do something about it? Or do we just brush it under the rug? So I really ask you to consider, where are we and what are we doing to make sure that we don't have to worry about a union coming into our facility? Let's move on to workplace rules and handbooks. So another case came out beginning of August. Like I said, the NLRB is on a roll. They have been very, very busy. So this is the Stericycle case. This case is important because if you have a handbook or you have policies, this case is going to it's going to influence you and what your policies are and how you may revise them. So I'm not going to dig into what this case overturned or what the past cases said. We're just going to focus on this case right now. So Stericycle focused on confidentiality with investigations, personal conduct, and conflicts of interest. So the board really is just turning back to like a case-by-case review, basically looking at two separate prongs when it's going to evaluate a rule. So the first thing that the board is going to look at is could, so not would, but could this rule in any way be interpreted to limit an employee's Section 7 rights? What are Section 7 rights? They're rights under Section 7 of the NLRA, giving employees the right to join a union, refrain from joining a union, and gather together collectively for the mutual aid and protection of their workplace. So if you have a rule that could be interpreted, to limit that behavior, even if there are many other interpretations, on its face, the board says, hey, look, that presumably is unlawful. Why? Well, because the board is not going to specifically enumerate which policies are and are not going to be susceptible to, Section 7 protected activity. So the second thing that we want to look at is the perspective of the employee. So typically we would look at a policy from a reasonable employee. Would a reasonable employee look at this policy and say, I think this is actually limiting my Section 7 activities? The board says, we're not doing that anymore. The board says, now we're going to look at policies from an economically dependent employee. Well, I don't know about you, but I think if you work, you probably are economically dependent, right? We're all coming here to get a paycheck. Yes, we may love our coworkers and we may love what we do, but we're equally dependent on economically dependent on getting that paycheck. So really, we're looking from the perspective of every single employee, not a reasonable employee. So if the general counsel can prove that, then the burden is going to shift to the employer to prove that, one, the rule advances a legitimate and a substantial business interest, and two, that the rule is the most narrowly tailored rule to meet that legitimate business interest. So what are some key takeaways to think about? I mean, obviously, one, it seems willy-nilly. Anyone can interpret this in any way that they possibly want to. I think the board is going to come down and find that a number more policies are unlawful. We'll see what happens with this case and if it gets to the circuit court, but it's just almost impossible for us to know how employees are going to interpret policies. We just don't know. Also, too, the board could find invalid policies based on circumstances that we could not have even thought of when we were drafting the language, or really that we didn't have that intent. So other things, look at your policies, right? Carefully review your handbook, your policies, and ask, do they actually advance a legitimate and substantial business interest? And are they the most tailored that they possibly can be? Also, make sure that you are documenting decisions relative to policies. You know, we are terminating you because of X policy. Well, is the policy going to violate Stericycle? And then also to just, key policies that you want to think about: social media, personal conduct, conflicts of interest, confidentiality. Those are policies that we always see the board going after. All right, lastly, let's talk about one of my favorite things to talk about: protected concerted activity. You do not have to have a union in your workplace for your employees to be covered and have the right to engage in protected concerted activity. So what is protected concerted activity? Well, it's typically 2 or more employees. They're getting together and they're attempting to typically complain about something, trying to improve their working conditions, wages, hours. Just think about people engaging in group action and making a complaint. It's a concerted effort. The purpose has to be for mutual aid or protection. It's not just employees griping about something, right? It has to be for mutual aid or protection, something related to work. Employers cannot retaliate against employees for engaging in protected concerted activity. If you do that, the employee is going to go to the labor board. They're going to file a charge. I will share with you, protected concerted activity, or PCA charges, are the #1 charge that I see at the labor board for companies that do not have a union. I probably have about 7 of them sitting on my desk right now. It's very easy for employees to find out about the NLRB, to find out about what their rights are, and to go to the board and file a charge. Employees, only employees are covered under Section 7 and have PCA rights. Like I said, it applies to union and non-unionized facilities, and it also applies in the workplace and online. All right, so have a question for you. We're going to play a little game. This is a new case that just came out, so I want you to think in your head, does the board say that this behavior is protected concerted activity? This new case, it's called Miller Plastic Products. And this employee, back in 2020, single employee alone, okay, is complaining about the company's decision to stay open during COVID. I'm sure a lot of us experienced that. This employee also attended a meeting, all-hands meeting with the CEO in March 2020, again complaining about the company remaining open, not closing. And lastly, the employee complained about another employee who had been sent home because his wife had contracted COVID. So ask yourself, when you think about what protected concerted activity is, typically 2 or more employees complaining about wages, hours, or working conditions, what do you think? What did the court say? Is this PCA or is it not? The court said that it was, and here's why. This is an individual's protest, but the protests are connected to group action. The reason for the complaints was to bring about group action. So the board said, absolutely, this is protected concerted activity. All right, one more case we're going to talk about. This is American Federation for Children. And again, I want you to think about, what did the board say about whether this is protected concerted activity? So we have a single employee alone, just like we did in the last case. This employee is seeking the reinstatement of a former employee who is waiting for some paperwork and to get approval on her authorization status. So she's not really working. She's not a what we might consider legit employee. And so the charging party in this case is going around talking to her coworkers to get other people interested in her cause to fight for having this former employee come back to work. So what do you think? Is that protected concerted activity? The ALJ said no, it's not, because this employee, this former employee, isn't an employee, and the employee who was complaining was doing this really out of their own interest, not of everyone's interest. The board said, hold up, wait, nope, this is protected concerted activity. Why? Because the employee acted concertedly, seeking to induce group support to ensure that this former employee actually could come back to work and get a job. And so the board said, hey, look, this employee who complained may actually have some type of benefit coming out of this. So a single employee complaining on behalf of a former employee, because that single employee may get some kind of benefit out of it, the board said, absolutely, this is protected concerted activity. So key takeaways: 1, former employees may be considered employees under the NLRA, and the scope of mutual aid and protection is going to cover efforts of employees to help themselves when they are helping non-employees. Thank you so much. We're going to hand it off back to AJ.
Thank you very much, Tricia. As we're going through our presentations today, there are going to be several opportunities during the breaks between substantive content to engage as an audience with some poll questions. It'll allow you to stay more engaged with the content and sort of reflect on what you've learned. It'll also give you a chance benchmark sort of your organization's thoughts and experiences against those of the others in our audience. But perhaps most importantly, it will also allow us to ensure that we can get continuing education credit in all of those states that require us to have poll questions. So the first poll question that we have is, in light of Stericycle, so this is the board decision that you just heard about that casts some doubt on policies and practices that infringe on employees' rights under the NLRA. In light of Stericycle, does your organization intend to change or review its handbooks or other policies? So to engage with the poll, you simply tap A, B, or C. A, yes, we're already reviewing. B, yes, we plan to review. C, no, we believe our policies already comply with Stericycle. Or D, no, we're comfortable accepting that risk of having policies that are not compliant. So I'm getting a sense, and many of you have already responded. If you haven't, please do take a moment, and then we will share the results across our audience. Okay. I have two, I have three kids now. I had a baby in January, and I keep forgetting to mention her. But I have two elementary school age kids, so I was going to count down to sort of force your behavior, but I'll try to avoid that instinct. All right, so most now, more than half have responded, so here's our response. About 18%, roughly a fifth, said yes, they're going to, they've already begun. 2/5 say that they plan to. 35% of you out there believe your policies are already A-OK, and a bold 5% are willing to run the risk that your policies are not compliant. So our next topic that we're going to be moving to now involves California. And my colleague, attorney Olga Savage, is going to talk about the policies that apply to employers and provide protections for employees in her home state, and discuss how they often set the stage for similar laws and developments within states and municipalities across the country. So we'll send it to you now, Olga.
Good morning and afternoon, everyone. Thank you so much for joining us today. Before I spend the next 20 minutes ostensibly bad-mouthing the state where I've happily lived since I was 6 years old, I do want to say that California has an incredible talent pool. It's got this really cool, creative, innovative business environment. We have Silicon Valley. It's wonderful. So there's a completely understandable and incredible opportunities and desire for businesses who may not necessarily originate in California to branch out to California, and especially now that we've got this very commonly used remote work environment post-COVID, where it's possible to be entirely outside of California, but maybe have 1 or 2 employees who are going to work entirely remotely within California and do an incredible job for your organization. They're amazing opportunities, but with those opportunities come additional responsibilities and obligations, and those obligations really involve knowing and understanding the laws in California that are very different from and unique to California employment law. So what I'd like to do in this presentation today is to just give you a taste of, if you are primarily doing business outside of California and you've got that one location, you've got that one remote employee who's in California exclusively, kind of what you're up against and what you need to be cognizant of, with a focus really in large part on what you need to be cognizant of, the additional laws and obligations specifically in the wage and hour context, because really that's where we see a lot of the really protracted, lengthy, expensive litigation, class actions, for example, you usually see in the wage and hour context, and candidly a lot of gotcha claims where well-intentioned employees who are trying to do right by their employees and take care of them and treat them well really get caught on the technicalities that are so common in California wage and hour law. So quick summary, you've got an employee in California, you've got a new facility or office in California. So what does that mean for your business? It now means that you have to be cognizant of new laws that are California specific. It means that you need to be cognizant of potentially new claims and remedies that are available to employees who claim that they were not paid correctly or that there was a wage and hour violation. And frankly, laws that straight out unequivocally conflict with laws of other states or with federal law. And I'm going to just take you through a few examples of that. But before that, just to set the stage for when you've got an employee in California. For employees who reside and work in California, California employment law is going to govern their employment. The location of the employee and not the employer is determinative. And the reason for that in large part is candidly because California is very, very, very protective of its employees. It deems protection of its employees under the laws that it deems necessary to be a huge part of its fundamental public policy, which means California is, unless there's very specific reasons authorizing it to do so, it's just not going to let other states govern the terms and conditions of the employees who live and work there. So California law is going to apply. And that raises naturally the question of, okay, well, what if in my employment agreement with my employees who are in California, I put an out-of-state choice of law provision? So we have the employee agree explicitly that the laws of another state are going to govern. That's something we see very commonly, especially in sort of the more complex executive comp type agreements that people have with the industries or businesses have with their employees, an out-of-state choice of law provision. It's very common. It's something that's commonly used. It can be used very strategically and effectively. Here's the problem, however. Effective a few years ago, the California Labor Code now says that it is unlawful for an employer to require its employees to sign an agreement with a non-California choice of law provision. So those type of agreements are now unlawful. And by that I mean any kind of agreement that relates to an employee's employment. So the employment contract, the offer letter, a bonus agreement, a confidential information and inventions assignment agreement, any kind of agreements like that, you cannot have a non-California choice of law or forum provision. It's illegal. Now, there is a limited exception to that. You can have a non-California choice of law provision in an employment agreement if the employee is independently represented by counsel in the contract negotiation. So let's say you're negotiating a contract with a fairly high-level executive and they actually have a lawyer representing them for these negotiations. You can have a choice of law provision that's not California in that type of agreement. But that doesn't really happen. And it certainly doesn't happen with hourly non-exempt employees who are in more routine non-executive positions where they usually wouldn't even have a written employment agreement. They would just have an offer letter. So you have to presume that in the absolute vast majority of cases, it's going to be California law, no matter where you as a business is located. What does that mean? It means that now you have to be cognizant of, even if it's just that one employee in California, you have to be cognizant of the California-specific wage and hour laws that are going to govern that employee's employment. And listing all of those laws is a whole full-day seminar all in itself, but just to give you a couple of examples. So California has overtime laws that are different from federal overtime law. You have to pay overtime if an employee works either over 8 hours a day or 40 hours in a week. There's a separate law requiring payment of double time, twice the employee's regular rate of pay, if the employee works over 12 hours. California has meal and rest break laws that don't necessarily exist under federal law or laws of other states. California law about payment of wages upon termination is different than it is in many other states. So, for example, in many states, if an employee leaves or is terminated, you can just pay their final paycheck on the next pay cycle. In California, if it's an involuntary termination, the employee needs to have their final paycheck in hand when they leave on their last day of employment. If it's a voluntary termination, you usually get up to 72 hours. There's no use it or lose it vacation policies, meaning if an employee accrues vacation, they're entitled to roll it over to the following year. It's never lost, whether they use it or not, and it has to be paid out upon termination. Our pay stub laws, and this is where I'm talking about employees getting caught sometimes on technicalities. So the California Labor Code has a list of 9 very specific categories of information that needed to be included on a pay stub. If even one of those categories is missing or is incorrect, the employee is entitled to penalties under the California Labor Code. The 50% rule for exemption. So, for example, for someone to qualify for a salaried exempt position under federal law, you just need to show that their primary duties are exempt duties. Under California law, it's actually a very strict numerical requirement. You have to show that they spent over 50% of their time on these exempt duties, and many, many others. So this is the substantive laws that are unique to California that you have to be cognizant of. And then separately, there's the procedural stuff, the different types of claims and remedies that are available to employees if they believe there was a violation. So the California Labor Code has all of these built-in statutory penalties, which kind of come automatic if a certain types of violations occur. But I think the one you probably hear about most, because I think everyone at this point, within or without California, has heard about the dreaded PAGA, right? The Private Attorneys General Act, which is essentially bounty hunter law. So the idea behind PAGA is it deputizes California employees to act on behalf of the California government. So it allows employees to pursue violations that the government doesn't have the time or the resources to pursue. It's a bounty hunter law. So what happens is an employee can recover penalties on behalf of other aggrieved employees for certain wage and hour violations. So it sounds like a class action, but guess what? It isn't, because the employee can pursue these type of claims without actually meeting all the very rigid requirements that they would otherwise have to meet to pursue a class action. And they get penalties, $100 for initial violations, up to $200 per pay period for any following violations on behalf of themselves and other employees. And then if they win something or they get something in a settlement, 75% goes to the state. They get to keep 25% as a bounty. And this is a claim that California plaintiffs' attorneys absolutely love. It's much easier to pursue than a class action, and it's become a huge part of California wage and hour litigation that's unique to California. So you've got those additional remedies, and then you've got the laws that just flat out conflict with federal law and other state laws. So federal law says this is okay. California law says that this exact same thing is not okay. And remember, when there is a conflict between California and federal law, the courts will apply the law that is most protective of employees, which 9 out of 10 times is going to be California law. So I'll give you kind of the most recent, hot, egregious, for lack of a better term, example, which is one that employers really get hit hard with in California. So under federal law, we have this notion of the de minimis doctrine. And what that doctrine means is, look, if an employee spends seconds or a minute or 30 seconds performing some form of task, they don't need to be compensated for this. Employers do not need to compensate employees for insignificant or insubstantial amounts of work. So if an employee takes 10 seconds to throw out the garbage on their way out the door after clocking out, the de minimis doctrine says you don't have to pay the employee for this. There is no exception for de minimis activity in California. California has said we reject the de minimis doctrine. Literally, employees have to be paid for every second that they work. And the famous case on this that we had recently in the California Supreme Court that we're all still shuddering about a few years later is this Troyster v. Starbucks case, where an employee basically said, look, after I clock out, I sometimes have to walk other employees out the door, and maybe on my way out, I see a piece of patio furniture that was left out that needs to be brought back in. So on my way out, I literally have to toss that chair over my shoulder to get it back into the cafe before I leave for the day. So the calculation was that that's maybe an additional 3 to 10 minutes a day of off-the-clock work, so about 12 hours and 50 minutes of uncompensated time over 17 months. Just to give you a sense of, if you convert that into wages, that means that the employee was underpaid by about $102.67. So in any other jurisdiction, in most other jurisdiction, and under federal law, the argument would be, that's de minimis. The employee doesn't need to be paid for that. But the California Supreme Court said, nope, we don't subscribe to that in California. That is a violation. He should have been paid for every second of that work, and he can pursue a class action based on those claims with all of the attendant wages that needed to be paid, statutory penalties, attorney's fees, and this is where that's a flat-out conflict between federal law and California law that you need to be cognizant of if you've got any number of employees in California. So that's just a very quick summary of the issue spotting that you need to be prepared to do if you do open a facility in California, and if you have just one employee in California. This is an ongoing knowledge that you have to have as you continue employing those persons. this is an update, so I did want to spend a little bit of time, or my remaining time, talking about some of the more recent issues that we've had come up in California over the last year on wage and hour matters, ones that are still relatively new that we're still coping with, that we're still trying to figure out how to address in California, because it's important, and really the moral of the story here is all of these changing, constantly evolving decisions on what is legal and what is not legal is something that you really, really need to keep up with, no matter how small your presence in California must be, is going to be. So I'll talk about just a few of the most recent cases and changes in the law that we've had happen recently. So we've had some decisions on time rounding, essentially saying that what we up till now thought was okay, facially neutral policies on rounding actually violate California law. And then we had a couple of not great decisions on PAGA recently that essentially makes it even easier for employees to pursue these PAGA collective actions and lawsuits. So I'll spend a little bit of time talking about both. So let's talk about rounding. So under the laws of many states, under federal law, under federal regulation, the notion, and up till very recently we thought under California law, it's deemed acceptable to round an employee's time, let's say to the closest 0.25 of an hour, 0.2 of an hour, et cetera, so long as those policies are facially neutral and they don't result in an employee losing compensation in the long run. Because rounding goes both ways, right? Under certain, for a particular day when the hours were rounded, they're rounded down. And then on another day, they round it up. So an employee may be slightly underpaid on one day, but they're going to be overpaid on another day because the rounding goes both ways. And up until very recently, that was even in California deemed acceptable. And not problematic so long as it's facially neutral and doesn't result in an overall underpayment of wages. Well, that is no longer the case. So we had two decisions recently, this decision of Camp versus Home Depot in October of 2022, and then Woodworth v. Loma Linda much more recently, just in July of this year, that found that facially neutral rounding policies violate California law. So the idea behind these decisions is, look, California requires that employees be paid for all hours worked, including small amounts of time. Remember, no de minimis doctrine, which means that when we say all hours, we mean all hours. And guess what, employers? We're no longer in the time of just physical time cards or timesheets. We've got this advanced technology now that really allows you to capture and therefore pay time by the minute that it's worked. You can't come back now and tell us, well, we don't know exactly how long an employee has worked because all we have is this written timesheet. No, you've got a time system that can track an employee's work down to the minute, so you have to do it. So no more rounding. And here's the interesting thing about the way courts in California usually decide these type of employment issues. What we see a lot in California is a lot of these decisions are retroactive. So we think that the law is one way, and then a California Court of Appeal or a California Supreme Court decision comes out and says, no, it's actually exactly the opposite. This is what the rule is, and by the way, this is the rule this is what the rule has been all along. So all of this time that you spend relying on our prior decisions that said something completely opposite, that said rounding is okay, for example, never, you should never have relied on that, because that's what the rule has been this all along. So you have violated this rule before you even knew that it was a rule, right? And that's where it gets really, really tricky. So now we've got an environment where basically, we're assuming for all intents and purposes we can't round. Now, these are just California Court of Appeal decisions. We don't have a California Supreme Court decision that says this yet. And actually, the California Supreme Court granted review of the Camp decision. So there is going to be, we don't have an exact timeline on when the decision will be issued, that there is going to be a decision from the California Supreme Court coming down the line on this. Being California attorneys, we're not overly optimistic on what that decision will be, but stay tuned. But for now, we have to operate under the assumption that there's no rounding. A couple of quick discussions on decisions that we had recently that makes it even easier for employees to pursue PAGA claims. So we had one of them, Adolph versus Uber Technologies. It came down in July of this year. It deals with whether or not PAGA claims can be compelled into arbitration. So for the longest time, it was understood, and there were decisions saying that PAGA cannot be arbitrated. You cannot require an employee to arbitrate a PAGA claim. Then in 2021, we had this great decision from the United States Supreme Court called Viking River, in which the Supreme Court said, well, yes, you can compel an employee to arbitrate his individual PAGA claims, and because there's no method for an employee to keep the PAGA claims on behalf of other employees in court while he arbitrates his individual claims, those claims should basically be dismissed. Well, the California Supreme Court said no. Even if an employee is required to arbitrate their individual PAGA claims, they can still separately pursue their PAGA claims on behalf of other employees in court. So now we're back to a situation where, okay, you might have an arbitration of the individual PAGA claims, but you're still going to be in court on the claims on behalf of all of the other aggrieved employees. So not a great outcome. And then you had this other decision, and we've had a couple of these already, but another one very recently in Woodworth v. Loma Linda, July 2023, which basically, in the past, we've had some courts agree that, look, you don't have to get class certification to pursue a PAGA claim. You don't have to meet that requirement. But if a PAGA claim is clearly unmanageable because there's just way too many individualized inquiries, the rules apply differently to one employee, the violations are based on what was said by a particular manager, happened at a particular facility, we can dismiss this PAGA claim because it's just not going to be manageable for the employee to litigate the claim and for the court to decide the claim on a class-wide basis for all of the employees. Well, now we've got at least two decisions, including this most recent one, that say, no, that's not a reason for dismissing a PAGA claim. So even if you have a situation where the employee's claims rest on all of these various individual issues, you can't automatically dismiss that claim based on that. So all these are kind of procedural technical issues, but they basically lead to the fact that now it's even easier for employees to pursue these PAGA claims. So quick overall, what does this all mean? It means that if you're preparing to open an office or a branch in California, if you're going to have one remote employee in California, you need to know these laws. And then what does it mean really quickly, just in the last little bit of time we have left for other states? Is California a bellwether of how things are going to go in other states? Is this going to spread? Well, maybe. I mean, we have seen situations where other states have adopted California changes on adding protected categories of employees who can't be discriminated against. Non-competes, right, is an area where states are becoming a lot more strict and adopting California's rules. Wage and hour, not so much in my experience. So I see states, for example, following in California's footsteps on things like implementing sick leave laws. Wage and hour, I haven't seen it quite as much, but you know what? It's possible. As we proceed, some states become more and more inclined to adopt these very employee protective laws, and to the extent that they have that inclination to do so, they're certainly going to look towards California, what California has done, and adopt that as a potential model. So stay tuned on that. In the meantime, please be cautious. If you do have California employees, call for help when needed. With that, thank you so much for your time, and I am going to turn this over back to AJ. Thank you.
Thank you very much, Olga. So with the end of her presentation, we get to our second poll question that's going to have you reflect on your what you learned or already knew about the complexity of California law, and think about your organization and whether or not California's regulatory framework, which is more complex and onerous than most, does it affect your organization's interest in maintaining or increasing your workforce in California? So your options are yes, we avoid adding workers in California when we can. No, because we already don't have and likely won't ever have California employees. Or no, because the regulations do not outweigh our need for employees in California. So take a moment and think about your organization, plans for the future, decisions you've made in the past, and whether or not California is a market or a labor force that you are trying to avoid, or one you're trying to accommodate and comply with the complexity that was just laid out by Olga. So again, we'll give everyone an opportunity to respond, and I do appreciate your responses. We're going to have, this is another short break, so we'll have another minute or so before we move on to our next substantive presentation. And once we reach a critical mass of responses, we'll take a look at how people are thinking out there. So I think we will go ahead and move to our response screen now. So we see about a third say, yeah, we try to avoid it. About a third, a little more than a third, say no, because California is not on our radar at all. And then a third that, or a little less than a third that say California is too important and something we can't miss to avoid it, so we're going to have to accommodate and work through all of those complex issues. So next up, we're going to move to a presentation that's going to be put on by attorneys Jenna Brofsky and Paul Potler. They're going to go through a practical guide to investigations that follow from employee complaints. Before I send it to them, I did want to provide you all with a quick and easy opportunity for a fun game you can play along at home. So one of our next two presenters is pregnant, and as you're watching their presentation, see if you can notice any subtle hints or giveaways and see if you can figure out who it is. Now, to be very clear, I'm pretty sure I got permission from Jenna and Paul to do this and to advise you in that way. If not, maybe we'll be going through a practical experience of a workplace investigation on our end. But in the meantime, let's send it over to Jenna and Paul.
Thanks, AJ. One, I'm going to be very disappointed if I win the poll question on who looks pregnant, but thank you. I am Paul Potler, along with my partner Jenna Brofsky. We're going to present on internal investigations today. Internal investigations of friends and colleagues. When we each get up in the morning, it's not how we hope to spend our day. But obviously, it's an important part of what we as HR and legal professionals have to do. It's an important component of not only risk management, but continuing to build and maintain the workplace environment that we all hope to have. Our presentation today is going to focus on 4 scenarios. We'll talk about them in a way that we hope is practical, but in our estimation, these are stumbling blocks that we see again and again in the course of internal investigation. So what we're going to start with is a brief overview, a baseline of why and how to conduct an investigation, but it's going to be quick. Then we'll focus the majority of our time on the 4 scenarios. And then we'll close with some practice pointers. So put on your track shoes. We're going to go ahead and start very quickly with the nuts and bolts. All right, when and why to investigate. First, the why. It's pretty obvious. It's the last bullet point there. To either remedy the situation, ideally, if our investigation can identify and help us remedy a situation, that's ideal. But in the instance where we can't get to that happy conclusion, at the very least, an effective and thorough investigation and supporting activity afterwards helps us limit the liability risk. So second, the when. Again, these are all the other 4 or 5 bullet points are all the triggers. And again, there's nothing there that's really going to surprise much of anyone. If something comes forward, if someone brings a complaint forward, if there's a report by a manager or an employee, if someone at an upper level, a manager or supervisory level, sees or observes something that may be inappropriate, even if it hasn't been reported. And personal experiences, just what is observed in the workplace, understanding if there are some red flags that need to be followed up on. And again, the when and the why, it's important that investigations be conducted promptly. One entirely avoidable bad consequence is when something's identified that it needs to be investigated, but it's put on the back burner for weeks or months until the company can get around to it. Bad things can happen, so that has to happen quickly. Not necessarily the same day, but reasonably quickly. Okay, some general guidance. Again, most of these aren't going to be too surprising to you. You want to gather and identify documentation, electronic, paper, anything that may be needed to see the hard copy information of what you may need to have. You need to gather and identify relevant witnesses and decide on a game plan of in what order and who's going to be interviewed. Come up, obviously, you don't want to go in cold. You have to come up with your written outline of questions. And again, the outline is the key, not hard questions where you just write down the answer, an outline of topics so that you know to move on and build off each set of questions. And again, a game plan for how you're going to document the meetings and the interviews. Now, one of the most important things that I think we have to make sure to keep in mind is that when starting an investigation, you want to make sure to determine the scope of what you're trying to accomplish. And that is either. It can be one of really three main items. It can be simply to gather information, and that's legitimate. It can be just an information gathering investigation. It can be information gathering and drawing a conclusion of sorts. Again, that's a different step you may or may not want your investigator to do. And finally, it can be not only information gathering and perhaps a conclusion, but recommendations for next steps based on it. It's important to know what the scope is going in so you don't start stepping on toes. Have recommendations by an investigator that upper management never conceived they'd get a recommendation from, and may be inconsistent with how the company wants to move forward. So it's important to decide that scope before moving forward. All right. With that overview then, let's go ahead and move to our first scenario. First scenario, Jim is a witness of a workplace altercation. But Jim's now traveling in Europe. Because the company was paying attention, they don't want to wait the 3 weeks till Jim comes back in order to interview him. So the company wants to interview Jim via Zoom. Jenna, you see any issues there?
Thanks, Paul. So one of the purposes of this scenario is to get you to think, where is Jim located? What jurisdiction am I in? And is there anything specific I should be thinking about? So Jim is in Europe, right? And in the EU, there's a very specific regime for data protection. The General Data Protection Regulation has been in effect now for about 5 years, and it relates to data subjects, which are your employees, and personnel data. Now, we're not going to go into a ton of detail other than to say that the GDPR also has prohibitions on cross-border transfer of data. So data coming out of the EU related to your employees. So we want to be mindful of where Jim is, and can we, in fact, record or collect information from Jim. Now, speaking about recording, we also need to be mindful if Jim is traveling in a different state. In the United States, the states are kind of divided. There's about a dozen states that require two-party consent to record a conversation. Illinois is one such example. So let's say Jim was in Missouri normally and he's vacationing in Illinois, and now we want to record his interview because we think it's going to be so helpful to our investigation. Well, can we do that? Should we do that? Something we should be thinking about. And we're probably not the only ones who are thinking about recording the conversation. Our friend Jimmy may want to record the conversation as well. So what does our policy manual say? That's for you to figure out before you start the conversation. But even if our policy manual says, hey, you know, you're not supposed to record these conversations, our friends over at the National Labor Relations Board of recent have taken a different approach. And in one recent example, they found that recording a conversation with management is actually protected activity under the National Labor Relations Act. So Tricia touched on this a little earlier today. Depending on the facts and circumstances, Jimmy's recording could actually be protected activity. So even if our policy says you can't record, we want to be mindful of how the National Labor Relations Board is going to treat that recording. And finally, when we're thinking about this situation, the practical is we want to get this investigated right now, and that's valid. But if it's 4 o'clock here and it's midnight in France, Jimmy might not be able to jump on the phone at that moment in time. Jimmy may also be on vacation. He might be on paid time off. Do we want to bother him? He might be on unpaid time off, and gosh, do we need to be thinking about whether we need to compensate him for the time in this investigation? There are a lot of issues that can arise when we're interviewing somebody outside of the workplace, and it's important to sit down and be mindful of them before we start the investigation. I'm going to jump to scenario 2 now, give Paul the chance to weigh in. Scenario 2 involves Tanya, and she is the subject of another employee's complaint. So somebody has complained about Tanya, and her employer learns through the investigation that she has engaged in some serious violations of the law. I know Paul's dealt with this before, so Paul, what do you think?
Well, obviously, this scenario is designed to show us, get us to talk about the obligations that arise for reporting illegal activity. And we do see this. We see it most often when IT has had to look in someone's computer and comes across some evidence of inappropriate activity. But that's not the only way. The general rule as far as obligations, the general rule is there's no obligation to report. You can report it. You don't have to report it. If you choose to report it, we have some suggestions. if you are supporting it, make the report factual. Take it to appropriate authorities, let them know what you've seen, not any conclusions you've drawn, and let the authorities draw their own conclusions, trying to keep you away from defamation claims there. So again, you can report it, make your report factual. The other, I think, item, when you are deciding whether to report or not, is not to fall into the trap of determining whether to report or not based on whether or not the person signs the severance package. It is human nature to say, well, this can all go, we're going to fire you for something, and this can all go away. We're going to offer you this separation package, including that we won't report this to the authorities. Be very, very careful with that. That becomes awfully close to blackmail. You waive claims against us and we won't report you. I'd counsel 99 times out of 100, you don't want to tie any kind of reporting to the execution of a release or waiver. So that's the general rule, no obligation to report. But there is a huge exception to that general rule. More than one, but one very big one that we want to talk about. And that is when you have stumbled across evidence of child sexual exploitation. Again, that normally comes up. There's been a problem on someone's computer or someone had to go look for something and they stumble across video or photographic evidence of kiddie porn, child sexual exploitation of some sort. If it's electronic, if it's on the company's systems, if the company provides those systems, there are both statutory and in some cases common law obligations to report that to the appropriate authorities. All right, so you've got that obligation. In addition, if such evidence is on company computers, the company is now in possession of illegal contraband, and the company can be held liable. So very carefully, want to make sure, one, you don't delete such info. That might be the first reaction. Let's delete this and get it off of there. This is terrible. Don't do that. You don't want to destroy evidence. In that opportunity, I'd say reach out to your counsel, whether that's us or someone else. Get them to help you reach out to the FBI or the U.S. attorney, because these are, again, federal, state violations, criminal conduct, and you need help moving that through in an appropriate way. Done correctly, cooperating, it doesn't have to shut down the entire business. It doesn't have to be the FBI marching in and taking everything out. It can be handled professionally and appropriately if the company's cooperating. So I encourage you to recognize that red flag and go that route. So on that really light note, let's move on to the next scenario. All right, next scenario. Excuse me, hold on if I got the, there we go. The next scenario, Margot complains about harassment by a coworker, and she provides some information, screenshots of certain text messages. But she provides what she wants to provide and doesn't provide everything or access to her phone. When she's asked about it, she refuses to provide access to her phone. Obviously, some red flags there. Jenna, what would you do?
Absolutely, and I actually was on a call with a client this morning about this very scenario. So if Margot is the complaining witness, we want to understand as best as we can what's going on. So part of this is explaining to Margot, we need this information in order to conduct an adequate investigation. We need this information to corroborate, and we need this information to take corrective action if corrective action is needed. I was in a mediation a couple of weeks ago where an employee refused to provide text messages, did provide the text messages only at the mediation months and months later. Text messages were not great, but at the time, employee hadn't provided them. And what the EEOC told her verbatim was, well, ma'am, you hamstrung the investigation by not providing those text messages. So it is beneficial to us to inform the employee, hey, we need these text messages, and if we don't get them, to document that information because, again, we can't adequately investigate. part of this is also making Margot feel comfortable. So limiting the scope to messages between Margot and the person that she's complaining about. And that doesn't mean you necessarily need to take her phone. We may be able to do that through screenshots, but we want to work with Margot to see if there's some kind of narrowing or limitation that would allow us to see the full story while also making her feel comfortable. And if Margot refuses to cooperate in the end, document, document, document. You'll hear that again and again and again. It's important later on down the road, again, if the employee is trying to say we didn't adequately investigate her complaints. All right, Paul, last scenario. Salima is a bystander witness. So that means that she is on the side, watching in, seeing what's going on. She does not want to participate or be involved in the investigation. Maybe somebody else brought her name up. That often happens when we're doing these investigations. We say, who else should we talk to, or who witnessed this? And they might say, oh, Salima was, sitting next to me the whole time. So Paul, what do you think? She doesn't want to participate. Do we just say, okay, that's fine, or do we do something else?
Well, I think we definitely at least do something else. This obviously is an offshoot of the last question, with someone who refuses or is reluctant to fully cooperate in investigation. Here, it's not a target or the complainant, but it's a bystander, a witness. So normally we'd recommend taking at least a somewhat softer approach. What I've done, and it happens quite frequently, you get at least reluctance, if not outright refusal. Typically, we remind the witness of the policies and the company's commitment to anti-discrimination, harassment, or whatever the investigation might be designed to root out here. Remind them of the seriousness and how important it is and how serious the company takes these issues. It's important to emphasize the no retaliation portions of the policy, and that nothing bad will happen to this employee for participating in the investigation. And finally, to remind them of their obligation, not only their obligation under the policy, but their obligation to their fellow employees to help stop behavior that's inappropriate and may adversely affect the workplace environment that everyone is striving to maintain. In my experience, 80 or 90% of the time, once you've gone through that, the employee gets more at ease and typically participates. But what if they don't? That's obviously the next question here. If they still decline, can you discipline? Can you force them to participate? Well, one, this is still America. No, you can't force them to participate. Can you discipline them? Yes, you can discipline them. Do you want to? That's a judgment call. There can be serious repercussions in terms of morale, if nothing else, for forcing or for disciplining someone. And again, discipline doesn't have to be termination. It can be a suspension. It can be a write-up. But technically, the refusal to participate in an investigation is insubordination. So you've got that opportunity. Be careful. Again, the gut reaction is to treat it on a case-by-case basis. If you feel like the person's refusing to participate because they're covering for the person complained about, you may be more inclined to discipline. Whereas if you get the feeling that they're just scared and fearful of retaliation, you may be less inclined to discipline them. That's not illogical. That's legitimate. Just understand that over time, you'll want to make sure that you're not disciplining all the people of a certain gender or a certain race or things like that for not participating while letting others off. Again, it's a stumbling block. If you know it going in, you can think about your options, and it's always good to step back. Don't make knee-jerk reactions and decide to discipline right then. Step away from the interview with someone who declines to participate and decide what to do before circling back. All right, well, with that in mind, then, I'm going to turn it back over to Jenna, who'll talk about some practical considerations and close us out.
Thanks, Paul. So when we're doing these investigations, it's really important to address both confidentiality and non-retaliation. As to confidentiality, what do we mean when we say confidentiality? there's some points in times where we may need to share information, and we want employees to be aware of that and comfortable with that. We also want employees to know that we have a non-retaliation policy, meaning that because they participated in the investigation, they're not going to be retaliated against. And it's good to document that you've shared that information with the employee in the course of the investigation. Emphasize the purpose of the investigation. For example, this is fact-finding. We're trying to understand what happened. Remain neutral and maintain objectivity. Ask open-ended questions, followed by more specific questions. For instance, we had an investigation recently where internally they asked, "Sir, did you engage in any inappropriate conduct?" And he obviously said no. Well, we came in there and I said, "Sir, did you say," insert inappropriate commentary, and he said, "Oh yeah, I did say that." So it's important to follow up with those specific questions. Avoid confrontational or accusatory questions. And remember, the last bullet point, remember to circle back with the complainant after the investigation is over. Most people tend to forget this. You know, we've had a conclusion, it's done. It's really important to go back and say this has been substantiated or unsubstantiated. There's been corrective action taken. Now, in the case that the joke that AJ put out there, let's say Paul was the complainant in that situation. So there's an investigation done, they come to me, I say, AJ he did have permission, it's okay. Well, then you need to go back to Paul and say, "Thank you so much for raising this concern, Paul. It's not been substantiated, there's been no discrimination here, and thanks so much for your complaint." And with that, if you have questions, better call Husch Blackwell. All right, I'm gonna pass it on back to AJ. Thanks, AJ.
Thank you very much. Oh, yeah. Thank you very much, Jenna and Paul. As you can tell from that last slide, we are not intellectual property lawyers. We have them at the firm, but our group is not. So we will just assume that use of copyrighted material is perfectly fine. And it's actually a good opportunity to transition to our next break. So we have a little bit of a longer break this time. It's going to be about 10 minutes. So if you need to step away, please do. For those of you who stick around, we do have some additional information and content for you, a little bonus topic that maybe you weren't expecting. And it's something that we like to do during our breaks, our longer breaks, which is sort of provide practical, maybe not necessarily legal tips for managing, this complicated world, both as an individual, as a member of an organization. So specifically today, we're going to talk about how to avoid common scams, schemes, hoodwinks, grifts, cons, hustles, flim-flams, and bamboozles. Now, this is not intended to be an exhaustive list. If there's some additional word or synonym that we could have come up with, just assume it's going to be covered. As long as it's somebody trying to take advantage of you, we're going to help you out. And so when we're talking about scams, we are typically talking about money, and we're going to talk about scams that try to target you as an individual, and we're specifically going to talk about some that really get and have some serious real-world consequences. So there was a law firm, not our law firm, who recently made some news because they were unable to recover some funds that they had wired when they fell victim to a scam. It was a classic scam. They were approached by a client that said, "A company owes me a debt. Can you please help collect on it?" The company, the firm sent the letters. Were successful, got a check from the target for about $200,000, deposited that check, it cleared, they wired the money to who they thought was their client in a successful operation, patting themselves on the back for having recovered the money so quickly, and then found out that the target, their client, was fictitious, the money went overseas, and the people who'd sent the check, of course, were also working with the client, and it was a fraudulent check. So they found themselves out. So there's some real risk here, and that's because these are serious issues. We have many of our clients who have experienced the old fake hiring scenario. So we as organizations, we use Indeed and LinkedIn and things like that to post positions. Scammers will do the same. They'll pretend like they're a legitimate company. They even use the names of some of our clients in their letterhead. They hire people. They use that to get information that allows them to then steal their identities, take advantage of them, and then we have employees calling us and saying, "Hey, when do I start? I'm excited." And we say, "We don't know who you are, and we certainly didn't hire you." So these are very serious topics, and they're certainly no joking matter, which is why we're going to spend the next several minutes making jokes about them. So a little history, I think, of sort of the scheme and scam world is useful as background as we're trying to avoid falling victim to it. So the first one we're going to talk about is pyramid schemes. Now, you're probably familiar with the concept of a pyramid scheme where somebody at the top takes advantage of rungs of people below, but that's not actually where that term comes from, or at least based on my research, it isn't. Because the pyramids themselves were a scheme or a scam that was meant to take advantage of ancient Egyptians, because they were actually billed out and sold as timeshares. So, not to suggest that all timeshares are scams, they're certainly not. There is a lot of improper activity that can surround them with high fees. And the pyramid scheme with the timeshares really comes to light when you think of the timeshares are tombs, right? So these are for dead bodies, in theory, forever. So it's a lot harder to timeshare a tomb where presumably your dead body will get some amount of time and then have to make room for other dead bodies. So you may not have known that, but that I believe is where the timeshare, or the pyramid scheme comes from. Now, the other pyramid scheme you may be more familiar with is the concept of chain letters. So this was a brilliant idea that I experienced when I was a young person. You get a letter in the mail, which is always exciting. That letter then identifies how, for a very small amount of money, you're going to get a whole lot of money. As a young person, I thought that was how the world worked, so I got excited. Here's an example from 1935 that's on your screen right now. It invites the individual to send a dime, just a dime, 10 cents, that's nothing, to one recipient, put their name on the list, send it out to 5 people, and eventually, when their name made it to the top of the list, they would get a whole bunch of money. So the math actually works out, and I think it's worth looking at. So you're at the top of the pyramid, right? So you send it to 5 people, then they send it to 5 people, then they send it to 5, and they send it to 5, and they send it to 5, until eventually you get to the bottom rung. This is where you start getting letters back. And the math checks out. That's 15,625 people. You're getting a dime from each of them. That's $1562.50. That's some real money, even especially in 1935. So like I said, the math checks out, right? We say from the letter, 15,625 letters. And that's going to net you, about $1536.50, which actually, as I look at it now, $1536.50 is not, that math doesn't check out. Maybe the best way to find out where the issue is there is for us to test this out. So here's what we're going to do. When you get a chance during the presentation or after, I'm going to ask you to email 5 of your friends. Send them my name, send them my Venmo ID, put your own name on the list. Direct them to send it on to more people and to send me $2.23. I've obviously adjusted the dime for inflation since 1935. And then eventually we're all going to profit. Or at least that's my understanding of how these pyramid schemes work. Now, don't actually do that. There's a quick lawyer disclaimer, because I'm pretty sure we'll all go to prison if we do. I'm not a criminal lawyer, so I don't know that for certain, but I certainly don't want to risk it. Another historical example is a Ponzi scheme, something you may have experienced. Made famous by Charles Ponzi, which I think if you saw somebody dressed like that right now, saying you can get rich quick, you should immediately be alerted. Bernie Madoff had a very famous Ponzi scheme. This was an investor fraud scheme. But less popular, but just as dangerous, is something called the Fonzie scheme. So this was something that I experienced a couple years ago. So there was an advertisement, seemed directed to me, right? Who wants to buy a bronze statue of Arthur Fonzarelli? It was only $9,000 and some change. I mean, not even $10,000. But there was some fine print that struck me as unusual, and it said that I had to pick it up in Milwaukee, and the address would be provided later. And when I got to Milwaukee, I found out that the statue was a lot larger. It's actually life-size, as we can see with the actor next to it. It took a lot of work to get that off the ground and was able to take it home. And it caused a bit of a media flurry and fury, I should say, in Milwaukee. And I did, at the advice of counsel, eventually return it. But I did not get, unfortunately, my $10,000 back. So the way you probably experience frauds these days are through emails primarily, right? We have a robust system to protect us from it, but they still get through sometimes. So here's one I received from King Charles II, telling me that his mother had died. He had a lot of money he was willing to share with me. And if you look close now, we're going to help you identify where's the risk here. So the first risk is, or how you know it's fake, right, is several of these words. It's just not how the British spell it, right? Recognized has an S, traveled has 2 L's. Labor has a U. I'm sure that jumped out at you, right? So this is probably not coming from a legitimate British person. And on top of that, he called himself King Charles II, and you didn't have to watch 24 hours of coronation coverage to know that that's King Charles II, and he died in 1635, so he's not sending you any money. Right? We're dealing with King Charles III at this point. And then finally, he talked about being in the United States playing polo in January of 1990. Excuse me, but that match very obviously happened in February, as anybody who's obsessed with polo and the royalty know. So another example, this is a letter that I got, or an email I got from somebody named Leah Johnson, which happens to be my wife's name and happens to be my wife's email. And it said nice things, good morning. It asked me to click a link and pay $100 to sign someone up for soccer, Edith, which is my daughter's name, and then someone named PJ, which is my son, pay for school pictures. But there was a giveaway in this, so I did not click those links, thankfully, because the email ended with, I am proud of you, and that's where the subterfuge really fell apart. So next we get text messages as well. So here's a good one that I actually received. Hello, I am from U.S. government. Send $1,500 in iTunes gift cards, or I'll be under the rest. I did not send any of those gift cards. And text messages can come, looking in a lot of ways, some surprising ways. So for example, I received this message. This is a direct message on Instagram from somebody calling themselves Michael Jackson, telling me that if I gave them money, they would start making music again. And then they added the nice hee-hee at the end, which was obviously an effort to convince me that it was really Michael Jackson. Next up, we get an email from somebody named, let's send this one. I'm clicking on the wrong things here. There we go. From somebody named Warren Buffett, right, who says he's the chairman of Berkshire Hathaway. He wants to give away his money. And all I have to do in order to get that money is send him a copy of my driver's license or my passport, my full name, my gender, all of this information that will obviously help him. Now, at first I was offended by this email because it specifically said that I was less fortunate, right? But then I thought less fortunate than Warren Buffett is not such an offensive idea, and who doesn't want $2.5 million? So I sent the information, and I'm waiting for it to come pay. And while I'm waiting for that check, we do want to go to a quick poll question. So this is under the category less of interacting with the subject matter and more just like getting to know our audience. So for example, you're going to have an opportunity to tell us what your mother's maiden name is. We're going to go through what street you grew up on, who your favorite teacher was in school, your favorite or your first pet, the last 4 digits of your social security number. I think it'd be kind of fun to see if anybody's line up. And then maybe the other 5 digits of your social security number. So we'll have that poll go live here, and actually I'm being told I'm not allowed to let that poll go live, and instead it's time to send it to our next presentation, which is Tyler Hibbler and Ben McMillan, and they're going to be giving us an update on the future of non-competes and how recent government action may require change for your current non-compete systems. So now we'll send it to Tyler and Ben.
Thanks, AJ. My name's Tyler Hibbler. I'm here with my partner, Ben McMillan, and good afternoon. Over the next 20 minutes, we're going to examine recent government actions that place the future viability of non-compete agreements, which, to be frank, most employers have, into serious doubt. Currently, there's approximately 30 million U.S. employees who are subject to non-compete agreements in the United States. To put that into context, there's about 167 million employees who work in the civilian workforce in the U.S. So approximately 20%, just under, about 18% of employees are currently subject to non-compete agreements in some way, shape, or form. Additionally, surveys indicate that upwards of 38% of the current workforce has been subject to a non-compete at some point in time during their career. Suffice it to say, non-compete agreements have been a large part of American business for decades. Traditionally, they've been put into place in connection with C-suite employees in order to protect trade secrets and other legitimate business interests. However, recently we've seen the growth of non-competes to other areas, and as a result, we're starting to see pushback from the federal government. Currently, the FTC proposed a rule in January of this year which would effectively eliminate non-competes as they currently exist. Additionally, this year the NLRB's General Counsel issued a memorandum indicating that non-compete agreements may violate the National Labor Relations Act. During our presentation, we're going to talk about these, discuss them in detail, and identify what they mean for employers. Additionally, in connection with these federal actions, we've also seen several states that have passed legislation in recent years that restrict the enforceability of non-compete agreements. So when we're talking about non-competes, what are we discussing? Non-compete agreements prevent former employees from using confidential information, trade secrets, and other information they gain through their employment or skills they gain through employment in competition with their former employer. Those state laws may vary, and traditionally non-compete agreements are controlled by state laws and are very state specific. The general landscape of an enforceable non-compete agreement involves a reasonable temporal restriction, a reasonable geographic restriction, and some sort of legitimate business interest that is being protected by the employer. Some states also hold that a non-compete agreement is unenforceable if enforcement of the agreement would impact the public or inflict some sort of undue burden on the employee. This is really easy to think about. Think about the context of physicians, and we'll talk about this later when it comes to state restrictions on non-compete agreements. That is one area where many states have determined that enforcing a non-compete agreement will have a drastic impact and harm the public. Therefore, they're not valid. So despite the fact that non-compete agreements have been traditionally enforced by state governments, vary state by state, as I indicated, there's now a federal push to start becoming involved in non-compete law and rein in the scope and enforceability of non-compete agreements. And to that extent, Ben, you can discuss the FTC's proposed rule.
Thank you, Tyler. I want to thank all of you for being here with us today. We always look forward to the opportunity to get in front of you and talk about these issues that affect each and every one of you on a day-to-day basis. I can tell you, I've been doing this 13 years, there is nothing that gets clients more fired up, in my experience, than when an employee goes out and breaches a non-compete agreement. Obviously, in employment law, we deal with a lot of hot-button, sensitive personal issues. As I said, there doesn't seem to be anything that is more upsetting to an employer than when they enter into an agreement with an employee. They pay that employee some form of consideration in exchange for that promise, and then that promise is promptly breached. I can tell you that I have seen courts become increasingly hesitant to enforce these agreements. They've become increasingly suspicious of the underlying reasons for them. So the national and local tide does seem to be changing against these agreements. I think it's also interesting, there seems to be both politically a conservative and progressive case against them. Obviously, the progressive folks tend to be more concerned about the employee entering into an agreement, not really from a position of much leverage with the employer. The conservatives tend to argue that they interfere with and restrain competition, which is ultimately bad for the consumer and bad for the economy. So with that, the federal folks are chiming in through the FTC's proposed rule. Now, the FTC exists, or at least their stated mission, is they exist for two reasons. That's to protect the consumer and to protect competition. So this rule really flows from that second purpose, trying to protect, increase, and prop up competition. The agency's quote on this is rather grand. It says, "Freedom to change jobs is essential to economic liberty and to a competitive, thriving economy." So that's the motivation behind this. That's why the folks in Washington are doing what they're doing. The rule is profound, it's significant, but it's pretty straightforward. The proposed rule would effectively ban non-compete agreements. It would also apply retroactively, and it would extend beyond simple non-competes, but also into sort of de facto non-competes, which we'll talk about now. So again, the rule would apply to employees, independent contractors, interns, externs, apprentices. Basically, if you're buying or selling goods or services in the American economy, this rule would apply to you. As indicated, not only would it prohibit the typical non-compete agreement, hey, you promise not to work for a competitor within this area for 2 years after the conclusion of your employment for any reason, but it would also extend to de facto clauses like non-disclosure agreements, confidentiality agreements, non-solicitation agreements of customers and of coworkers. Now, for those to enter into or under the scope of this rule, they would have to be more broadly drafted or broadly understood or broadly applied, such that they would function to interfere with or prohibit or dissuade an employee from seeking other employment. It's the FTC's functional test. So if this were to become the law of the land, and it hasn't yet, and there's no clear indication one way or the other, it would also serve to invalidate such de facto clauses if they're broadly defined and if they function to dissuade an employee from competing against their employer. So very aggressive, very broad, very significant, and certainly worth your time and attention. So talking a little bit about penalties and enforcement. The FTC estimates that this would result in an increase in the earnings of American workers of $250 to $296 billion if this rule were to go into effect. And incidentally, I think that's what Chris Jones is asking for to play defensive tackle for the Chiefs, but I digress. There are a lot of administrative hoops yet to jump through. There's an open comment period. Again, within the administrative body, there are a variety of different challenges and procedures that would have to be followed for this to ultimately become law. And make no mistake, there will be significant challenges through litigation and through the courts. But the rule is going to be no joke if it goes live. There'll be a required rescission of existing non-compete agreements within 180 days of the rule going into effect, and a required 45-day notice period to employees who are bound by it. And violation of this rule could result in legitimate penalties, both civil, injunctive, and indeed criminal penalties, getting the Department of Justice involved. So again, while not final, this law certainly has some teeth, and we all need to be paying close attention to how it's progressing.
Let's discuss that. Let's talk about the current status of where this rule's at, Ben. The comment period for the proposed rule ended back in April of this year. Over 27,000 comments were submitted in connection with this proposed rule. Recently, it's been issued from the FTC. While initially they indicated they may vote on this in April of 2024, looks like they will take a vote on this proposed rule in April of 2024. So that's the timeline that we're looking at. We have April 2024 as being the potential date where the FTC will vote on this and it could be put into place. If it passes, as been indicated, most legal commentators anticipate the rule will be subject to heavy litigation, likely will be challenged very early within federal courts, and there will be multiple litigants which will seek stays of the implementation of this rule. So that's something to keep in mind. The basis that most commentators think this rule will be challenged under are essentially that the FTC lacks the authority to engage in this rulemaking. Either it is a non-delegable obligation that belongs to Congress, or that the FTC is exceeding the scope of the authority that's been delegated to them in regulating commerce. Either way, we do have some runway here for employers to get up to speed, to get things in gear and prepare for this. While we can't sit here and predict what the future will hold in connection with this rule, I do anticipate that the FTC will likely implement the rule in April 2024, absent some sort of changes taking place. So it's something that employers need to be aware of. They need to be cognizant of how they can comply with this rule, and they also need to be aware that legal challenges will take place as soon as the rule comes into effect.
Tyler, this is not going to come as a shock to you, but our friends over at the National Labor Relations Board would like to get in on the fun here. In May of this year, the NLRB issued an advice memo basically saying that non-compete agreements, as we typically know them, run afoul of the National Labor Relations Act. And it's an interesting first thought. Like, why would the NLRB be wading into the non-compete waters? Well, the argument advanced is that overbroad non-compete agreements would serve to chill employees in their exercising of rights under Section 7. And Section 7 of the NLRA deals with concerted activity. Concerted is often a word misused and overused, but essentially it means working in concert with your coworkers to organize and bargain for better working conditions and other terms and conditions of employment. A couple of examples given by the board in this advice memo would be that non-compete agreements could serve to restrain or interfere with or prohibit an employee from concertedly threatening to resign, from following through on those concerted threats to resign, from concertedly seeking other jobs within the industry or jobs that would compete with the employer with whom they entered into the non-compete agreement, or it would interfere with their right to solicit customers and coworkers. And again, these are all the types of conduct and behavior that Section 7 is aimed at protecting. It's an interesting angle to say that Section 7 or the rights guaranteed by it would somehow be interfered with by non-compete agreements. But again, that's something certainly to be aware of. I think a lot of folks make the mistake of thinking that, hey, the NLRB and its advice memos and the NLRA don't really apply to me because I have a non-union workforce. That is not true. And I think all of you have probably heard a little bit about protected speech under the NLRA and how that applies to even a non-union context, but the same is true here with respect to non-compete agreements. Now, the NLRB did give one carve out here. It said, look, if this were to become law, then non-compete agreements that prohibit employees from taking a management or ownership role in a different company would be allowed. But the good old-fashioned, hey, you can't compete against us at all under this advice memo would no longer be valid.
And it's not just the NLRB or the FTC that employers need to be aware of in terms of regulating non-compete agreements. There's been an increasing trend amongst states to also restrict or flat out ban non-compete agreements. States across the country have passed legislation limiting the enforceability of these agreements. For example, several states, including California, Oklahoma, hinting on the more conservative states also having an interest in this, and Minnesota have passed laws which effectively ban non-compete agreements. New York has recently passed a law which is awaiting signature from the governor there, which we anticipate will occur, which will put them in that camp as well of effectively banning non-compete agreements with employees. So not only is this something that employers need to be aware of on a federal level with the potential actions by the FTC and through the General Counsel's memorandum with NLRB, but also employers need to be aware of the states in which they're operating and how having a non-compete agreement, perhaps a universal non-compete agreement that all employees sign, which is something we frequently hear, could be invalidated by state-specific laws, especially in the time of remote work. Other states, such as Colorado, Washington, Illinois, have also implemented restrictions on non-competes that make them invalid for employees who are making under a certain specific amount a year. For example, I think Colorado's salary threshold is just over $100,000, $101,000. So if you are an employee in Colorado making less than $101,000 a year, you cannot have a non-compete. Illinois has instituted that at $75,000. So something, again, to be aware of based upon where you're employing individuals and where you're conducting business operations as an employer. Finally, some states have passed laws which ban non-competes for specific positions or specific roles. This circles back to what I mentioned earlier about the public interest and the potential public harm that could arise from non-competes. Traditionally, we see this in the context of healthcare providers. For example, Delaware, Massachusetts, and Rhode Island have all instituted bans on non-competes in some way, shape, or form pertaining to physicians. Additionally, Indiana just joined this group as well this year. Effective in July of 2023, Indiana instituted a ban on non-competes for primary care physicians. Texas is another example. Texas requires that there is a buyout clause for physicians who are subject to a non-compete, and the law in Texas requires that that buyout be reasonable. So you can't look at a physician and say, hey, your buyout's $2 million to get out of your non-compete. No, it must be reasonable based upon a multitude of factors. So again, this is a three-front war effectively on non-competes that employers are currently facing. And to do to make sure that you're appropriately prepared, you need to institute some best practices, and we have some suggestions when it comes to that. First and foremost, in light of the increasing federal and state hostility toward non-compete agreements, you should take a long look at your current agreements, analyze who is subject to those agreements, what positions, salary ranges, and make sure that those agreements are actually designed to protect legitimate business interests. You should ensure that your existing non-compete agreements contain reasonable geographic and temporal restrictions and are justified, again, by legitimate reasons. If you find yourself in court trying to enforce a non-compete, that is the first thing a judge is going to look at is, one, what is the legitimate business interest that's at issue here? And two, is the scope, the temporal scope, the geographic scope of the non-compete reasonable? Additionally, employers should review other provisions of their employment agreements and contracts to make sure that they are, one, compliant with the potential law, whether it is through the memorandum from the NLRB or the FTC, but also to make sure that they are strong in other areas, such as protecting trade secrets or confidentiality. So those things need to be looked at as well.
Yeah, I would dovetail on that. I think being selective, not only in who you give non-compete agreements to, but also in who you seek to enforce them against. I've had some experiences with clients who legitimately enter into a non-compete agreement, but the employee and the job that they're doing, it just was unlikely that a court was going to enforce that. And then you run the risk of getting an order from a court at the preliminary injunction hearing that can be used against you in the future. So being mindful of whether or not that agreement is really enforceable before pursuing litigation, I think is really a good idea. We all need not despair completely about this proposed rulemaking. Number one, it is just proposed rules at this point. And there will remain, even if the worst case scenario unfolds and non-competes are blown completely out of the water, you'll still be able to pursue claims under the Uniform Trade Secrets Act and related state statutes. And again, unless confidentiality agreements and non-solicitation agreements are so overly broad that they function to restrain an employee from pursuing competitive employment, those provisions will still be enforceable. So we won't be powerless to make these employees keep their promises. It will be more difficult.
And Ben, if I can jump in, one thing that I've noticed and recommend to clients, and it's indicated here, is having a clawback agreement. And so what are we referencing by clawback? It's making sure that employees have an obligation to return documents or materials to the employer upon the termination of employment. Having a provision which requires the return of that information is perhaps the best methodology that an employer can have to make sure that information and documents are not being disclosed to a new or potential employer. It also provides a breach of contract mechanism to obtain return of those documents.
I would agree completely. I would agree completely. And as always, when in doubt, reach out to your friends at Husch Blackwell. We're here and we're happy to help.
This time we'll toss it back to AJ.
All right, thank you. And we are now at our third and final legitimate poll question of the day. And this question asks, does your organization use non-compete agreements with its employees? Yes, the majority of our employees are subject to non-competes. Yes, a select few of our employees are subject to non-competes. No, we used to, but not anymore. Or no, we have never used non-competes with our employees. So take a moment to register your response, and we'll give everyone a chance to think about how their organization uses or doesn't use non-competes at this time. And then we'll see where you stack up against the rest of the population. We're almost to that critical mass, so we can take a look. Let's do that now. So yes, majority is about 10%, 11% of our audience. 2/5 of you out there have a few employees, 10% used to but don't anymore, and about 40% of you don't use non-competes with your employees. So certainly the changes that are happening have happened and will continue to happen in the non-compete space. It's going to impact a number of you out there. And now we're going to send it to our final presentation of the day, which is going to be my colleagues Jeff Trottier and Eric Eisenman. We're going to talk through an update on ESG and DE&I programs, managing the political and the legal pushback that we're seeing for those programs. So take it away, Jeff and Eric.
Thank you, AJ. Appreciate the opportunity to be with you all today. As AJ mentioned, my name is Eric Eisenman. I am a partner in our Milwaukee office. I'm joined by my partner, Jeff Trottier, also in Milwaukee. Jeff and I are excited to learn who stole the bronze fawns from the Riverwalk in Milwaukee. We understand that was AJ.
I've missed the bronze fawns a lot.
Right. So it's back. Our Milwaukee friends who may have been paying attention to the news recently saw that the bronze fawns was actually defaced in the last week. That is also still an open investigation, but I think we have our first suspect. I might use some of the tips that I learned during the presentation from Paul and Jenna to conduct an effective investigation, which would probably include some forensic exams of AJ's text messages.
I think so, and I am not looking forward to reviewing those.
Not looking forward.
No.
Those are not going to be good. But thank you for sticking with us today. We're excited to talk to you a little bit about a topic that I think is in the news a lot, and that is ESG and DE&I programs, particularly in the employment context, in the corporate context, and how the ground is moving a little bit here in terms of legal challenges to these programs. So. A little bit of an overview of what we're going to cover. We'll talk a bit about sort of, again, the definitions of ESG and DE&I. We'll talk about some of the reasons that our clients or some of our clients invest and continue to invest in these sort of programs. And then I'll talk a bit about some of the things, as I mentioned, that you've probably been reading about, which is legal challenges to initiatives that have particularly picked up in light of the recent Supreme Court decision that I'll mention. And then finally, we'll end with some tips or recommendations for employers that wish to continue to maintain and invest in these programs and give you some advice about ways that you can do that in a lawful fashion. So let's start with ESG. Jeff, can you tell us what that is and what that means in this context?
I would love to talk about ESG. The thing about ESG is, compared to DE&I, it is less known. People are less conversant in it. So first of all, what is it? As you can see on the screen, it's environment, social, and governance. So what does that mean? This is really your employees' overarching concern with what is their company doing, where are they placing their financial assets. It seems like a new concept. The term ESG comes from a 2004 United Nations report, but it has its roots way back in the 1950s and 60s. Labor unions would be directing their pension funds what to do with the capital assets in those funds before they actually came to fruition. And they were really directing those funds to things that would benefit the community, like creating affordable housing or building health clinics in underserved areas. Fast forward to the 1970s, and we see ESG thoughts in the disinvestment in South Africa during apartheid. Now, in the current climate, we have employees who are just concerned with environment, social, governance, so much so that it drives their employment decisions. Looking at environment specifically, they're concerned with how companies are stewards of the natural world. So this comes in the form of healthy workplace initiatives, sustainability oversight and compliance, and supply chain awareness. Where are the components they're working with coming from? What are the conditions under which they're produced? Looking at the social plank, they're concerned with how the companies are benefiting their employees generally and globally, and also the communities that those companies serve and where they're seated. This comes in the form of DE&I initiatives, which Eric's going to talk about more, and flexible work schedules, remote work schedules, making accessible community places to work, and mentorship opportunities, whether it's external or internal. Looking at governance, they're concerned about how companies do govern themselves internally. They want to know what the corporate board is composed of, not just as far as diversity goes, but internal and external ties, and how that structure propels the company forward. They're concerned with pay equity, workplace safety and harassment policies, and training. These employees want training. They want these topics talked about. And the community service initiatives that the company has put themselves behind. Now, in turn, the companies generally with an ESG focus have put in place a lot of initiatives under these three planks. Under environment, and we can go back to the last slide, please. Under environment, they have to do with the climate, climate change, biodiversity, greenhouse gas emissions, waste management, water management, sustainability generally. Companies are putting initiatives forward, of course, under social with respect to DE&I. They're creating intentionally integrated work teams and have an eye towards human rights and consumer protection initiatives. Governance is where it becomes a very interesting situation because a lot of companies are stressing reporting transparency, where it has to do with salaries and profits and investments a company is making. A lot of companies right now are commissioning pay equity studies, which then they repeat every few years to make sure they remain on track. They have very prominent business ethics policies. And they also are disclosing corporate political contributions with an eye towards transparency again. But moving forward to the next slide, we can talk. There is an ability to measure your ESG process. It is a very measurable goal, but you want to be objective when you do this. So a lot of companies are engaging outside organizations to make these evaluations for them. What we have on the slide is a good typical breakdown or example of what we would see in the measurement process. We look at governance, and you can see under there, sadly, I cannot see the bullet points, but if I recall, they're looking at things like oversight and
governance principles.
Thank you, Eric. Eric has
risk management. Yes.
And we generally focus about 15% on that. Leadership and reputation, about 10%. The culture of ethics gets a good 20%, and then we're going to look at environmental and societal impact for about 20%. You'll notice 35% is ethics and compliance. That's because ethics and compliance and everything under that, like policy, procedure, training, structure, that structure propels all of the other aspects of ESG. And also it has a nice tie-in of satisfying pre-existing legal responsibilities like having a safety procedure and safety training, having harassment training and harassment procedures. And with that, let's talk about DE&I a bit.
Great. Thanks, Jeff. That's a good overview, I think, of ESG. The other three-letter acronym that is getting a lot of attention and has gotten a lot of attention is DE&I. Notably, in the center of our slide here, we've got belonging. And you may have read some recent news stories that are identifying that some businesses that have maintained diversity, equity, and inclusion programs have now inserted this concept of belonging in place of, for instance, equity and inclusion. So some businesses are now calling these programs diversity and belonging. Part of the reason for doing that, and the reason that belonging is sort of at the center of this circle, is all of these concepts are focused on, an employer's ability to create an atmosphere that's welcoming and supportive of employees. And that, again, can be focuses on enhancing diversity in the pipeline, so getting a more diverse population into your organization, creating opportunities for promotion for diverse individuals, and we define diversity very broadly, along with those concepts of equity and inclusion. So, we talked about the ESG concept. I like the way that Jeff described sort of the evolution of this, but I think it would be accurate to say, this is front of mind for employees more than it ever has been in the past. Same thing for DE&I. This slide that we have right here shows what essentially, I think, a representation of why and how this is important for a current workforce. On the left side, you've got a breakdown of survey results from employees who identify as members of Generation Z. On the right side, you've got a breakdown of employees who identify as members of the millennial generation. And essentially, to distill down what we're looking at here is this idea that for individuals who prioritize these goals, who say that the social impact or the commitment to sustainability that they see in their organization is very important, and they are satisfied with that, those are folks that are sticking around. Those are people that are likely to stay at the organization for 5 or more years. Employees who do not see that in their workforce, who perceive that these are not values that are supported by their employer or supported in the way that the employer advertises, are the employees that are most likely to depart over a shorter period of time, 2 years or less. The other thing that I think is interesting is you can compare these two cohorts in this slide, is you can see that this is becoming increasingly important to the younger generations that are moving into the workforce. So I've previously identified myself as an elder millennial or a geriatric millennial. I was born in the early 1980s. But we've got an even younger cohort of employees moving into the workforce now. And you're seeing that these concepts are becoming more and more important to them. So this has been, I think, a fair overview of why what these topics are, how they're important. So I'm going to pivot now to talk a bit about, again, what we're observing, and that is increasing legal and political pushback in this context. So on this slide, I've got a list of some examples of companies that have been in the news over the last couple years because their corporate DE&I programs have been challenged in some way. So the first example, Comcast. Comcast implemented a program that was essentially a underserved or minority small business initiative. They were going to give money and support small businesses, but those businesses need to be owned by female or minority individuals. That was challenged in a federal court lawsuit on the basis that discriminating against members of the majority was inconsistent with federal law. That case was settled before we ultimately got to a determination, but it was a bellwether, I think, of sort of some of these challenges that we're seeing. Wells Fargo made a commitment to interview diverse applicants, but the data ultimately suggested that some of those interviews were sham interviews. They weren't actually interviews for the positions that were in place, and they were hit with a shareholder derivative suit from a shareholder saying, hey, your wasted resource and time in this area had a negative impact on the financial performance of the company. Danaher Corporation, similar situation. They made a commitment to DE&I, and their commitment was that they were going to include at least one member of an ethnic minority on their board. They failed to follow through with that, and so they were hit by a shareholder derivative suit. Compass Group, this is an interesting example, and one that resonates with another news story that I recently saw. Compass Group implemented a mentoring and training program. They wanted to create opportunities within their organization for diverse employees to be promoted. And so they had a special program that was built for diverse employees. Unfortunately for them, they had a formal rule that said white male employees were not eligible to participate in the program. And so they were challenged on that basis, that excluding a class, even if it was a historically favored or overrepresented class, exposed them to liability. Starbucks, similar example, and I want to jump down to Harvard. This is the big one that you guys will recognize that was in the news, the Harvard and UNC affirmative action cases that were really recently decided by the Supreme Court. Ultimately, what I'll say about that is that those cases related purely to higher education. By their terms, they do not address and you may have heard us talk about this in a prior series that we did on DE&I. They did not specifically address employer DE&I programs. Having said that, we are seeing an increasing number of sort of individual lawsuits, statements by political figures, arguing that the Supreme Court's position in those cases should impact what an employer does from the DE&I perspective. So, good things to have on the radar screen. As we move forward here, how can you continue to implement DE&I programs, ESG programs in a way that's going to minimize that legal risk? Actually, before I get to that, Jeff, I wondered, did you have an example of a litigation that involved an ESG program?
Actually, two. One, American Airlines. There's a former pilot who he just brought this suit, I believe he filed it in August as a class action, targeting the American Airlines 401k because it includes a particular fund, a BlackRock fund, the 2045 fund, in fact, which uses ESG considerations. And the pilot's words were that it pursued leftist political agendas and was flatly inconsistent with fiduciary responsibilities. So he's suing on that basis. Now the question is, did he actually ever select that as one of his investments? So that's going to be a stumbling block we watch. Another one is the Texas Attorney General is suing the Biden administration because there is an ERISA rule that the administration just put in action that says you can consider non-financial attributes when managing assets. So we'll see. But then there's the argument that if those assets are market-driven and the market is calling for ESG considerations, is that actually appropriate?
It leaves employers and businesses in a difficult spot. We acknowledge that. There is risk now, as you listen to some of my examples, damned if you do, damned if you don't. There are employers that are being sued because they're not following through on their DE&I or ESG commitments. There are employers that are being sued because shareholders and employees are arguing that those commitments are inconsistent with the law. Can you still do these things? Can you still invest in these areas? Our advice to our clients that are asking for our assistance in this area is yes. If you do so, that you have to be intentional about it. You need to make sure that you are measuring, designing your programs to address those goals, and applying them in a way that is compliant with the law. Don't make those sort of obvious mistakes like the entity did, where they said you're going to exclude a class of individuals. It's okay to implement plans and programs that eliminate barriers to entry or give opportunities to folks who have not traditionally had opportunities and support folks in that regard. But you don't want to be drafting those plans or communicating that information to employees in a way that's going to specifically exclude any class. I think that's a red flag and something that can create risk. So, we are advising our clients that there is still a way to do this to effectively meet those goals and also to protect yourself from litigation. That's it for our substance today. I am going to hand it back to AJ for a couple closing comments. Thanks very much.
Thank you very much, Eric, and thank you all for joining us today. We hope that you enjoyed the information, that it was helpful to you and your organization. Noticed as the presentation was going on that many of you took advantage of a new feature that we have where you can react to our presentations in real time with emojis. Was not allowed to mention this earlier, but that's actually pretty important for us because most of our compensation for this year is going to be tied to the amount and types of emojis that we received while we were presenting. So hopefully you took that responsibility seriously. A couple of reminders. The program has been approved for credit for HR and legal continuing education, so make sure you fill out the forms under that CEU icon to report it for yourself. Under the information tab, you can receive a copy of it, and you will receive an email that will include a certificate of attendance and a link to the recording of this presentation for your viewing pleasure. And certainly, if you haven't already, do take some time to complete the survey. It's really helpful for us to get that feedback and to help us guide what our programming looks like in the future. And with that, this concludes our program, and thank you.